Please, Lordship. Lordship, I beg to mention item 10. It's the last item on the list.
My lord, it will be a joint prayer, my lord. It will be a joint prayer, my lord.
It's connected to
number 10.
that transport checkers matter, Lordship.
Yes.
So we have, it appears there's some bearing with the matter pending before the Honorable Supreme Court.
Okay, so you have, because you have to confirm that.
Lordship, there appears to be, because for us to go into that exercise of trying to pick out the, may not be required, Lordship. So we'll wait for that, whatever happens in the Supreme Court.
It is the joint submission of the learned counsel for the respective parties that there are matters pending before the Honorable Supreme Court, which, when decided, would have a bearing on the merit of this case. Accordingly, it is prayed that this matter may be adjourned for the time being. On pre-meet, this is matter up to 4 weeks.
Obliged.
The release item number 1.
Please, Lordship. Lordship, this is a quashing petition, my lord, pertaining to a case in East Gentile Hills District, my lord, session case number 21 of 2023. My lord, this case involves the allegation of robbery and attempted murder on one Srimati Agnes Karsheng way back in the year 2018, my lord, 8/11/2018. The police, after conducting investigation, my lord, they have filed charge sheet on 14/3/2019. And they have charge sheeted around 26 number of accused, my lord. I'm one of the accused person. My lord, the matter was taken up for hearing on framing of charge, and we have argued, my lord, but the learned trial court has rejected our prayer. Although there's no direct evidence against us, my lord, the statement of the victim as well as another victim is there, my lord. There are two victims. Nowhere points to our involvement in the case, but the learned trial court has refused our prayer for the charge only on the ground that there were some reports in the charge sheet which mentions that about CDR, that we were in at the time of incident. CDR points out that we were around the place of incident, my lord. One of the accused person also whose prayer of the charge was rejected was one Poimi Sana. So we have approached this honorable court, my lord. Similar evidence was available against him, and this honorable court was pleased to discharge him on by order dated 5/2/2024. So we are on same footing, my lord.
Yes.
My lord, Learned AAG will be leading this matter. However, he is before court number 2, my lord.
You are accepting notice?
I'll accept notice, my lord, for the day, my lord. For all the respondents.
All the respondents?
My lord, they are only officials, my lord.
Any records required?
We have annex.
They have an X, my lord, the charge sheet copy.
FIR charge sheet and the order dated, my lord. At present, the trial is proceeding, my lord. PW1 has been examination in chief has been completed, so it's pending for cross, my lord.
How many witnesses are there?
There are many witnesses are there, my lord. Listed witnesses around 34, my lord. 34. So we are yet to complete with the first witness itself, my lord. His examination and cross-examination is pending.
When was the charges framed?
Charges was framed, my lord, on 5/2/2024, my lord.
All these statements under 161, 164 are here?
Yes, my lord. Yes. Because the charge sheet itself, my lord, basically reproduce all the statements.
No, exactly. But there must have been a number of witnesses whose statements were taken during the investigation.
Yes, my lord. The charge sheet is a detailed one, my lord. They have produced the 161, 164 statement of the witnesses.
So we'll admit this petition. My lord, is the matter for hearing. Mr. Sheila?
Yes, yes, my lord.
Heard Mr. Jishla, learned counsel for the petitioner, who has submitted that the petitioner has approached this court with this instant application under section 528 BNSS public 482 CRPC seeking discharge from a case being Sessions case number 21 of 2023 under section 307/392/34 IPC pending before the court of the learned Sessions Judge. Which district?
East Gentle Hills District.
East Gentle Hills District. Wherein he was implicated as one of the accused person therein. Prayer for discharge have been made before the trial court, which was rejected. Hence this petition. On the Ms. Arkolni Laraji has accepted notice on behalf of all the respondents and has prayed that this matter may be posted for hearing on the next date. Prayer, Lord.
My lord, a small prayer, my lord. It seems 164 statements not reproduced in the charge sheet, so I'll bring it on record, my lord, of the victim, my lord.
You see, 164 not only of the victim but of all the
Yes.
relevant witnesses.
Yes. But in this case, it's only 164 statement of only the victim was recorded.
Oh, sorry, yes. Victim, Nestle. 164 would be of the victim.
Yes,
161.
Yes, my lord.
On primate, this is matter after 2 weeks.
So in the meantime, I'll bring on record those 164 statement also, my lord.
You can do that. Mr. Shalla has further submitted that this petition has been filed with certain annexures. However, certain important documents such as the statement of the alleged victim recorded under section 164 CRPC and some other related documents have not yet been filed before this court, for which prayer is made for the same to be for such papers to be allowed be filed by way of an additional affidavit. Prayer, Lord. Okay. But Mr. Shila, I just want to know, look at the area of respondent, SP East Gentle Hills. So when is Shillong made the capital of East Gentle Hills?
I'll correct that also, my lord, with permission.
Cut paste business.
I'll correct that also, my lord, with permission.
Do that.
Item number 2.
Acknowledgement.
Wait, please, Your Lordship. My Lord, this is an appeal in a land acquisition matter under the new Act, my Lords, against an order in a reference proceeding which was passed by the special court. We preferred this appeal and they filed an application questioning the maintainability. Their contention is that it is time barred. We've examined that matter, my Lords. We are not pressing this at the moment. In fact, on the last few occasions, we'd already informed the court that we are in the process of filing a 227 application. That matter has been prepared and has been sent to the learned AG. He's just examining that matter. We should be able to file it in a week or two. I'm just praying for some time. We're not pressing this matter at the moment, my Lords.
So what do we do?
And on the last date, it was placed before His Lordship Justice. Thank you. They had made a prayer for his recusal, apparently because he had appeared in the matter sometime in 1999. So that's how it's before Your Lordships today.
May I be the Lordship? Lordship, I'm very sorry to feel that on 3 consecutive dates they have taken adjournments. My Lord, this is a reference suit, appeal against the reference suit. So under the new Act, so they cannot take any such kind of time.
See,
my Lord.
firstly, I believe there is a misapplication for condonation of delay.
Yes, ma'am.
Yes, my Lord.
That has to be dealt with first.
Definitely.
So
Sorry.
now they have come with this plea that this petition may be withdrawn, and
No, ma'am, we've already made it very clear to them that we're not pressing this matter. But they keep insisting that we should do the hearing. I fail to understand why. If he's at liberty to file execution, he has an order in his favor. He does not want to file an execution for some reason.
My Lord,
But he's insisting that we should hear this matter.
definitely, because my Lord, as per the new Act, my Lord, this is already time barred, my Lord. So the delay cannot be condoned from any angles, my Lord.
we'll examine the matter.
Yeah, the delay because
But see, even otherwise, if the petitioner, you see, comes before the court and says that I'm not pressing the matter,
Lordship.
matter ends there.
We've made it clear, in fact.
no,
We're
actually,
just in the process of filing a 227 application, a separate
So
application.
naturally, this petition will be disposed of as withdrawn, and that will not affect you in any case
Lordship, exactly.
until and unless a fresh petition is filed.
Yes.
Then you have another course of action there.
Lordship. And we've told them that we'll serve them a copy as soon as it's ready for filing.
but they never pleaded that this to be withdrawn. They simply
No, we
stated
did
that
not say that. We said we are not pressing this matter. As soon as we file that, this will be ready for withdrawal. That's all that we mentioned.
this is the first time they
No, even on the last occasions we made it
my
very
Lord, this
clear.
is the first time they are trying the word withdrawal, my Lord. Previously they said that we are filing a petition along with this, my Lord. They're simply misleading maybe. They have said specifically, my Lord, they were filing a petition along with this, my Lord. That's why we are wondering what kind of
Made it
petition.
very clear we're filing a
No, my
227
lord.
application.
No, but what kind of petition along with this, my Lord, they can file of it. But as per the Act, my Lord, the delay appeal period is maximum of 60 days, and the delay continuation period is another 60 days, which comes to 120 days. Even a single date, if we are delays 121 days, also that cannot be condoned, my Lord. Here, my Lord, there is a delay of 183 days, my Lord, 184 days, my Lord. So there are several judgments of the Honorable High Court, Supreme Court also, my Lord. Even single day delay is also not condonable. And further, my Lord, they had applied for
You are Mr.
I Burwa.
Bora.
And further, my Lord, they had
See, Mr. Bora, we are not on that.
my Lord, my Lord.
We are not on that. This because the matter has not been taken up on board for hearing. Now, if they are saying,
Yes,
rather the learned counsel is saying that the parties is not pressing, then what does it mean?
that's why I'm shocked to hear today.
It means that
Yeah, they
matter
had,
ends there.
yeah, I'm shocked to hear today because last time also they simply said that we're filing together, let the matter
When
be
senior
listed
counsel
together.
was appearing, we made it very clear. Perhaps he did not
What you are
understand.
saying outside the court is different.
No, in the court itself, the learned AG has simply stated that they had prayed for a time, they will be filing a petition along with this, my Lord.
Is it there in the origin?
No, well, it's not that. We've already made it clear to them as well. We are filing an application under
Yes.
227. My friend has been insisting that I give him a copy.
Yes,
The
I
matter
was.
is being examined by the learned AG. So we've told him once it's ready, we'll serve you a copy.
Yeah, for 3
Just give us about 2 weeks' time.
Mr.
We're filing
Sen,
the 227 application.
You're not pressing the matter ends there. This
Yes.
matter will be disposed of.
No, on the next date, Milas. I'm just praying for some
again-
time.
again,
I'll make some references to this application only, Milas, because the learned AG will appear, Milas.
Here now
I
they
don't
are
have
making
that
again the
instruction.
same contradictory statements. Now he's saying that this will be withdrawn. Now
Please
that
just
is
make one
not
thing
being.
clear. There is
Two
an
contradictory
application for
statements here, sir.
condonation, so the matter has not been admitted. He's at liberty to file for execution. Nobody stops him, but he's not willing to file execution. I don't understand why.
Because let it be disposed of, my Lord. Let it be
So I'm
disposed
just
of.
praying
Because
till the next date, Milas.
no, we can go for execution, but let be disposed of. Since now they are making.
Just grant me 2 weeks' time.
two
Milas. In the
contradic-
meantime, we're filing a
Not,
227
my Lord, not more
application.
than a week. They have taken 3 adjournments. As per the new Act, my Lord, they cannot delay this matter. They cannot delay this
The matter
matter.
has come before this court for the first
For the
time.
first time, Milas. Exactly. And on the last occasion, they had prayed for recusal.
No. What?
I'll give you 1 week's time.
No, we prayed because
1 week's time.
1 week's time is fine.
maximum 1 week's time. Can it be on 19, my Lord?
Mr. Sir?
One more than a week ago. 19th Wednesday.
Okay, 19th is fine with it.
So on the next day they will be filing.
That's up to them. It's not for you or for me to say. Mr. Estelle, you're appearing as GA.
My lord.
There are GA appearing for the applicant, state applicant, has sought for accommodation for the day on the ground that this matter will be led by the learned AG who is indisposed. You are Mr. I. Borwa.
I Borwa.
Mr. I. Borwa. Borwa or Bora?
Borwa.
Borwa.
Right.
I correct name. Mr. I. Borwa, learned counsel for the respondent.
So
Though initially has raised objection to the pyramid, has however conceded that this matter may be heard, may be taken up on the next date. As agreed to by the parties, this is matter on 19th.
my lord.
I'll be pleased.
May I please, my lord? They've uttered the word to be withdrawn. That may be recorded, my lord.
Let it come.
Previously also they again made
Let
mislead.
it come.
Much obliged, my lord. Much obliged.
Item number 3.
This is the second appeal, my lord.
Just a moment. How many other items on the board we have?
10, your lordship.
Item 5 to 9, who's appearing? These matters are ready for hearing.
No, Your Lordship, this matter is pending for, I'm about to file a rejoinder, Your Lordship.
Why is it posted for hearing?
On the last occasion, the state respondents have filed an affidavit, Your Lordship, bringing on record some of the developments in the case, Your Lordship.
Okay.
I need to file a rejoinder.
So have you filed?
No, Your Lordship. I need some more time, Your Lordship. It's ready for my end, but I'm just waiting for my clients to come.
Okay, so I'll pass order. I'll give you the liberty to file the rejoinder.
Lordship.
I will post the matter for the next date.
Yes, Lordship.
Mr. Learned counsel for the petitioner who has submitted that the rejoinder affidavit could not may be allowed to. You're filing today.
No, not today, Your Lordship. On the next date, Your Lordship.
Could not be filed. Could not be filed today and has put it for some more time for the same to be filed. On premier, the same is allowed. This is matter to 2 weeks.
Yes, sir.
So that is 9 to
5 to
5 to
9.
9.
Connected, yes, Your Lordship. And
Obliged.
Please. Oh. Where were we?
My Lord, if Lordship recalls, I just started with the questions of law that Honorable Court had framed. I just started making submissions on that. Prior to that, my Lord, I had taken Honorable Court through the impugned judgment of the First Appellate Court. Lordship may kindly recall the First Appellate Court has declared my entire lease deed as an invalid lease based on First Appellate Court's observations or interpretation of something called Assam Frontier Tracks Regulation. And I had also shown that Assam Frontier Tracks Regulation has absolutely no application in this matter. And my Lord, even if it has some application, what the regulation state is that the commissioner has the power to declare certain laws as inapplicable. But whether Transfer of Property Act has been declared as inapplicable in tribal areas of Meghalaya based on that regulations, that is not there. That declaration is not there. So my submission before this Honorable Court was that the Appellate Court had materially erred in placing reliance on this frontier track regulations. Thereafter, my Lord, I had opened with the two questions of law that my Lord had framed right on the first occasion, on the first day of motion. The first question, my Lord, was whether a first appellate court can grant relief to the respondent in the appeal in the absence of a counterclaim or cross appeal. The relevance of this question, my Lord, lies in the fact that my suit was originally dismissed, but at that time also there was no counterclaim that had been raised by the respondents. So in other words, I had sought a declaration that I am holding a lease deed of 1923 and consequently I should not be disturbed. There was no counterclaim filed by them in respect of their 1914 lease deed.
Why would counterclaim be necessary?
Because what has happened is the matter involves a parcel of land. So once my suit got dismissed, there was an assumption on their part that that they are entitled to the land. So on the ground, what had happened is immediately after dismissal of the suit on 23rd December 2015, on 26th December, they landed up there on the spot with JCBs, etc., to take possession of the land. So the question was required to be answered that in the absence of any counterclaim, meaning no declaration in their favor, can they be granted any relief?
To claim that parcel of land which was earlier disputed.
Which is in dispute, my Lord. And this question, my Lord, assumes significance in view of the fact that there was no cross appeal also, which was filed by them in the First Appellate Court. If Lordship recalls, one of the issues was decided against them by the suit court. Issue being whether they had entered into a 1914 lease deed with us, and in 1923 did we give them back that disputed portion, that 6 acres of land. The finding of the suit court was no. In 1914 there was no lease deed entered into by them with us. It was entered into with some other third party, some other entity, and therefore there's no question that we have given back 6 acres in 1923 to them. So against that finding also, there was no cross appeal filed by the respondents. In that background, even in the absence of a cross appeal, the effect of the impugned judgment is that they have been granted relief. So I had sought a declaration from the suit court that in 1923 I had a lease deed that was denied to me. I had filed my first appeal. First Appellate Court declared my entire lease deed as an invalid document. Now, this was a surprising approach by the First Appellate Court for the simple reason that that document was not in dispute. Both parties agreed that yes, there was a lease deed of 1923. Since there was a lease deed of 1923, I am entitled to 10 acres of land. the 10 acres that is mentioned in that 1923 document. So that document not being in dispute could not or should not have been set aside by the First Appellate Court, especially in the absence of a cross appeal, my lord. So the first question of law that has been framed correctly, I would say, by this Honorable Court is whether the First Appellate Court could have granted relief to the respondents in the absence of any cross appeal, cross claim, etc. The answer to this question obviously should have been or would be no, my lord. In that respect, I had submitted 2 judgments on the last occasion. 1996 7 SCC 559, which essentially states an appeal. Lordship, there's a small compilation I had submitted. If Lordship looks at page 9 of the compilation, page 9 of the compilation, my lord, it's a 1996 judgment. 1996 7 SCC, page 9.
Page
9, my lord, of the compilation.
This is compilation of a relevant document.
No, my lord, there's another judgment compilation. That is the only thing. My lord is holding it.
This one.
Page 9 of this compilation.
1996 7.
7 SCC 559. Para 7, my lord.
Yes.
I'll quickly read para 7, my lord. It is settled law that the right to claim preemption must be available on the date of sale, the date of suit, and the date on which the decree is passed. In so-and-so versus so-and-so, this court has held that when appeal against a decree is pending, the Court of Appeal has cessation of the whole case, and the whole matter becomes sub judice again, sub judice again, though for certain purposes, that is execution, the decree is regarded as final. The decree of the trial court gets merged with the decree of the appellate court. Therefore, the Court of Appeal shall have all the powers and shall perform as nearly as may be the same duties as are conferred and imposed on the court of original jurisdiction. When the appeal therefore is pending in this court, it is a continuation of the original proceedings and the entire issue is at large. So the first proposition which I'm placing before this honorable court is that when the first appellate court was seized of the matter, it was in effect a continuation of the suit. The suit was still continuing, my lord. In other words, in very simple terms, my lord, the appeal is but a extension of the suit. Keeping that in mind, my lord, the next judgment, page 12 of this compilation, that is 2022 judgment, 2022 SCC online SC 928.
Yes.
Paras 16, 17, and 18. Lordship has come across this judgment in other cases. A very simple proposition of law here. 16, 17, and 18. I'll read 16. Coming to address the second issue, while the court is not apathetic to the predicament of the respondent grandparents, it is a fact that absolutely no relief was ever sought by them for the change of surname of the child to that of first husband, son of respondents. It is settled law that relief not found on pleadings should not be granted. If a court considers or grants a relief for which no prayer or pleading was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. In the case of so-and-so versus so-and-so, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. The court held as under, it is well settled that the decision of a case cannot be based on grounds outside the pleading of the parties, and it is the case pleaded that has to be found. Without an amendment of the plaint, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate in it an alternative case. Para 18, in the case of so-and-so versus so-and-so, it was held that, though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant of relief not even prayed for by the petitioner. So, my lord, the proposition is very simple, my lord, that relief granted by a court has to be based on the pleadings of the respective parties, based on the prayers that have been advanced. It was nobody's case before the first appellate court that the 1923 lease deed was an invalid document. It was nobody's pleaded case. It was nobody's argued case. So that being the position, when there was no prayer for declaring that as an invalid document, the first appellate court could not and should not have declared that 1923 document as an invalid document. So, my lord, going back to the question of law, whether first appellate court by declaring the 1923 document has effectively granted the entire 10 acres to the respondents. So, because if I'm not covered, if I do not hold a lease deed, a valid lease deed in respect of that 10 acres obviously reverts back to the respondents, my lord. So their claim, without filing any counterclaim also, but their stated claim was 6 acres. Instead of 6 acres, the entire 10 acres has been given to the other side without there being a prayer for that, my lord. So the first question has to be decided in the negative, my lord. The first appellate court could not have granted a relief which was not prayed for by the respondents, my lord. That is the first question. The second question.
Yes.
Second question. The second question of law which Honorable Court had framed was whether the provisions of the Transfer of Property Act 1882 have no application over the tribal areas of the state of Meghalaya in view of the operation of the Assam Frontier Tracts Regulation of 1880. Now, this question obviously is crucial for the reason that the impugned judgment has based itself exclusively on this Assam Frontier Tracts Regulation of 1880. The finding of the first appellate court was that that Assam Frontier Tracts Regulation 1880 has declared the Transfer of Property Act as not applicable in the tribal areas of the state of Meghalaya. On the last occasion, I had taken Honorable Court through the Assam Frontier Tracts Regulation. There is not a whisper of, there is no such whisper in that regulation that Transfer of Property Act will or will not apply in the tribal areas of the state of Meghalaya. So that being the case, a bare reading, where a bare reading of the regulations of 1880 shows that there is no such declaration under those regulations that TP Act will or will not apply. The learned trial, first appellate court could not have again come to the conclusion that because of these regulations, the Transfer of Property Act will not apply in the state of Meghalaya. The consequence of the TP Act not applying in the tribal areas of the state of Meghalaya are evident for all to see, my lord. There are n number of agreements, deeds, etc., which have been entered into over time. All those agreements, including my 1923 document, have now come under threat if this finding is stands and is upheld, that TP Act does not apply in the state of Meghalaya. Leaving that aside, even assuming for a moment that somehow the Assam regulations of 1880 have declared that the TP Act will not apply, I draw Lordship's attention to the judgment at page 19 of this compilation. Now, this judgment of 2012, my lord,
Yes.
it sets out a very interesting principle of law. It sets out what is known as the principle of destitute. Now, this principle of destitute, in very simple terms, it means that if a certain law or statute has not been in use for a very, very long time, that statute or law is deemed to have died a natural death through non-operation, non-use. If Lordship kindly looks at para 201 of this judgment, 201, page 20 of the compilation.
Yes.
I'll read. I'll read. From the above, the essentials of the doctrine of destitute may be summarized as follows. 1. The doctrine of destitute denotes a principle of quasi-repeal, but this doctrine is ordinarily seen with disfavor. Number 2. Although the doctrine of destitute has been made applicable in India on few occasions, but for its applicability, two factors, namely, number 1, that the statute or legislation has not been in operation for a very considerable period, and number 2, the contrary practice has been followed over a period of time must be clearly satisfied. Both ingredients are essential, and want of any one of them would not attract the doctrine of destitute. In other words, a mere neglect of a statute or legislation over a period of time is not sufficient, but it must be firmly established that not only the statute or legislation was completely neglected, but also the practice contrary to such statute or legislation has been followed for a considerably long period. So, my lord, this doctrine, as lordship would have seen, requires two things, my lord. A particular legislation not being used for a fairly considerable period of time, and number 2, the contrary practice being followed. If the legislation says a particular thing, the contrary has been followed for a considerable period of time. Now, the Assam regulations of 1880, assuming that somehow, somewhere, it says that the TP Act will not apply in the tribal areas of Meghalaya. Now, I base the submission on my limited experience with local laws, but Assam Frontier Tracts regulation of 1880, I would submit, is not something that has been used in any manner, in any form, for a considerably long period of time. If lordship recalls my submission on the first day of motion, after searching for 2.5 hours also, we could not find any reference to this legislation anywhere. Somehow before the final hearing we could get a copy of that Frontier Tract regulation, but no judgment, no precedent is there which shows application or use of this regulation.
So under what circumstances would this regulation apply?
If lordship looks at the regulation, on the last occasion I had placed a copy. Now this regulation, lordship has the copy?
Yes.
Yes. Now this regulation, if lordship looks at number 2, regulation number 2, power to direct enactments shall cease to be in force. When this regulation has been extended in manner hereinbefore prescribed to any tract, the Chief Commissioner may from time to time, by notification in the local gazette, direct that any enactment in force in such tract shall cease to be enforced therein, but not so as to affect the criminal jurisdiction of any court over European British subjects. So it gives the Chief Commissioner of Assam the power to declare that a certain law will not apply in the backward tracts, which includes Khasi and Jaintia Hills also at that time. Now that power has been given to the Chief Commissioner, but whether that power has been exercised to declare the Transfer of Property Act as not applicable, that is not clear, my lord. That is not shown through these regulations. There was a notification also referred in the impugned judgment on the next page, my lord. It's a notification from 1929. Now, second paragraph of lordship says, further, in exercise of the like powers, the Governor General in Council is pleased to authorize the Governor General of Assam in Council to direct, is pleased to authorize the Governor General of Assam in Council to direct that any act of the local legislature of Assam shall not apply to the said territories or to any part thereof, or shall apply thereto, subject to such exceptions or modifications as the governor may think fit. There is a schedule, my lord. It lists out the territories which are to be declared as backward territories. It includes, if lordship sees, number 2, British portion of the Khasi and Jaintia Hills district. Then the second portion of this schedule, my lord, the second table, the provisions of the said act which confer powers on the Indian legislature of Assam to make laws, respectively, for British India and for the province of Assam, shall be construed as requiring those legislatures, when making laws solely applicable to all or any of the territories specified in column 1, to insert in every law so made a provision that such law shall come into operation only on such date and subject to such exceptions and modifications, if any, as the Governor General or the Governor General in Council may by notification in the Gazette, as the case may be made direct. Now, similar to the 1880 regulations, this notification appears to give powers to the Governor General of Assam to direct that any Assam law, any act of the local legislature, that means Assam legislature, any law passed by Assam legislature, shall not apply to the backward tracts. Now, Transfer of Property Act is not an act or law passed by Assam legislature, it is a central act, my lord. So this notification on the face of it has no application vis-a-vis Transfer of Property Act. To answer Lordship's question, what was the purpose of the regulations of 1880? The purpose was to give power to the Chief Commissioner of Assam to declare that to declare in the official gazette that certain laws will not apply. Now, this was a British era power given to the Chief Commissioner. Last 75 years, it has not been used. There is no Chief Commissioner anymore who could have notified in the Gazette as provided under Regulation 2. So for 75 years, this notification, this regulation has not been in use. The first requirement of principle of destitute is...
After the transition of power.
Yes, ma'am. Yes, ma'am.
No. From the previous regime to
yes,
now, Union of India.
Yes, ma'am.
There has not been any change to this regulation. Repeal, replacement.
My lord, whether it's been repealed expressly, I am not aware. I'll have to look at that. But my understanding would be that this law, which granted power to the Chief Commissioner, has died a natural death, even if not expressly repealed, because after 1947, there is no Chief Commissioner anymore, my lord. There are Chief Ministers, etc. Different regulations, if there are any regulations, different set of laws will now apply. So from 1947 till date, I would say that this regulation has not been in use. So the first requirement of the principle of destitute is continuous non-use for an extended period of time. 75 years, it has not been used, my lord. The second requirement is, for the principle of destitute to apply, is that the contrary practice should have been followed. So even assuming for a moment that under these regulations, the TP Act, the Transfer of Property Act, was made not applicable in the backward areas, in the tribal areas of the state. Last 75 years, TP Act, the contrary practice has been adopted. Multiple agreements, gift deeds, leases, etc. have been entered into, have been registered under the provisions of the Transfer of Property Act. So the contrary practice...
Can you cite instances?
My lord?
Can you cite instances or give examples?
My lord, I would have to fall back on common knowledge, my lord. The instances...
Just saying so would not do.
My lord, but...
how do you establish contrary practice being followed?
The fact...
Like you said, perhaps, you may know it, I may know it.
Yes, my lord. Yes, my lord.
But how do we get it,
Understood, my lord. Understood, my lord. At the moment, I'm not equipped to answer this question. If Lordship gives me some time, I'll...
Because there would be some, reference.
My lord.
Such and such agreement has been made under the...
My lord, under the provision.
Particularly to the area concerned.
My lord. If Lordship allows me some time, I'll come equipped to answer this query that has come.
Because on that premise, then perhaps we may apply the principle of destitute.
Yes, my lord.
Here.
Yes, my lord. Very well. If Lordship allows some time, I'll come back better prepared for this issue, my lord, on this limited issue. If I can move on.
Please.
If I can move on. Now, principle of destitute applying on these regulations of 1880 means that these regulations could not have been relied on or should not have been relied on by the First Appellate Court. And, my lord, it is required for me to point out.
Yes.
It is required for me to point out, and there cannot be any dispute on this, it was no one's case neither of the parties had referred to these regulations, either in the suit court or in the first appellate court. No one had referred or relied or depended on these regulations in any manner. It came as a surprise to both parties, an unpleasant surprise for me and a pleasant surprise for them, that based on these regulations, which no one had spoken of, no one had made any submissions, the entire appeal had been dismissed, and my 10 acres in effect were given back, were stood reverted back to the respondents, my lord. So that is regarding the second question of law. Second question of law was whether the Transfer of Property Act applies or does not apply in the tribal areas of the state of Meghalaya in view of the regulations of 1880. Answer to this question, I would humbly submit, has to be no. No. There is no such exemption or no such application of these regulations which results in non-applicability of Transfer of Property Act in the tribal areas of Meghalaya. Now, these are the two questions that Honorable Court had framed. Now, I have one more submission on the questions of law that have been framed. I am certain it'll be the attempt of the other side, of the respondent, to try and convince this Honorable Court that these questions of law that have been framed are actually no questions of law, and that they should not have been framed. In response, my lord, I place a legal position for lordship's consideration that, leaving aside whatever questions have been framed or not framed by this Honorable Second Appellate Court, the fact of the matter is that when the judgment itself is perverse in facts or in law, then the perversity of that judgment itself becomes a question of law. If I can elaborate on this point with the assistance of a few judgments, if lordship looks at the first page of the compilation,
Yes.
it's a 2005 judgment, my lord. This judgment, para 36, next page.
Yes.
Para 36, I'll read, my lord.
Yes.
Section,
Excuse me. Please.
Section 10F, this is the Companies Act, my lord, 1956. Section 10F refers to an appeal being filed on a question of law. The learned counsel for the appellant argued that the High Court could not disturb the findings of fact arrived at by the Company Law Board. It was further argued that the High Court has recorded its own finding on certain issues which the High Court could not go into, and therefore the judgment of the High Court is liable to be set aside. We do not agree with the submission made by the learned counsel for the appellants. It is settled law that if a finding of fact is perverse and is based on no evidence, it can be set aside in appeal, even though the appeal is permissible only on the question of law. The perversity of the finding itself becomes a question of law. It goes on, but I am stressing on this, that if the judgment in question, judgment under challenge, is perverse,
Yes.
there are perverse findings, and I will show how there are perverse findings. If the judgment itself is perverse, the perversity of the judgment itself becomes a question of law. Now, whether this judgment, the impugned judgment of the First Appellate Court, is perverse or not, Lordship may look at one more judgment to understand what is perversity under law, my lord. That is at page 3, 2010 judgment.
Yes.
Para 28 of this judgment.
Yes.
I'll read para 28, my lord. I'll read it slowly, my lord. If a finding of fact is arrived at by ignoring or excluding relevant material, or by taking into consideration irrelevant material, or if the finding so outrageously defies logic as to suffer from the vice of irrationality, incurring the blame of being perverse, then the finding is rendered infirm in the eyes of law. If the findings of the court are based on no evidence, or evidence which is thoroughly unreliable, or evidence that suffers from the vice of procedural irregularity, or the findings are such that no reasonable person would have arrived at those findings, then the findings may be said to be perverse. Further, if the findings are either ipsi dixit of the court or based on conjecture and surmises, the judgment suffers from the additional infirmity of non-application of mind and thus stands vitiated. So, my lord, for a judgment to be considered as perverse, as para 28 shows us, it should, if looks at the first line, if a finding of fact is arrived at by ignoring or excluding relevant material. Learned First Appellate Court has ignored all materials, has ignored all evidence. Instead, Learned First Appellate Court digs up this regulation from somewhere and bases the entire judgment on this regulation. What did the evidence speak of? Everything has been ignored, my lord. So the first requirement for a judgment to be perverse, if there is a excluding of relevant material, that is present. First Appellate Court has excluded relevant material. Second way in which a judgment may be perverse, by taking into consideration irrelevant material. The First Appellate Court has taken into consideration this frontier regulations of 1880, which has no application, which does not say anything to the effect that Transfer of Property Act does not apply in the tribal areas of Meghalaya, but it has based its entire judgment on by taking into consideration irrelevant material, my lord. So, or if the finding so outrageously defies logic with respect to the First Appellate Court, this judgment, my lord, rendered by the First Appellate Court, defies logic, my lord. It defies logic for the simple reason that it was nobody's case that about the application of the Assam Frontier Regulations. It was nobody's case that the 1923 lease document is an invalid document. In spite of that, using what Supreme Court says, its own ipsi dixit, its own imagination, its own ideas, court has dismissed my appeal, my lord. So the judgment is perverse. There cannot be two ways about it. Judgment is perverse, and the perversity of that judgment itself becomes a question of law. So even if the argument is raised that the two questions of law framed by this honorable court are actually no questions of law, they should not have been framed, but there can be no running away from the perversity of the judgment under challenge. That perversity itself is a question of law, my lord. And if there is such a perverse judgment where the perversity itself becomes a question of law, the High Court can interfere, my lord, with perverse findings of fact. Page 6 may kindly be looked at of the compilation.
Yes.
Page 6, my lord, it's a 2010 judgment, para 10. Para 10, I'll read, my lord. It is settled law that in exercise of power under section 100, which lordship is exercising now, under section 100 of the Code of Civil Procedure, the High Court cannot interfere with the findings of fact recorded by the First Appellate Court, which is the final court of fact, unless the same is found to be perverse. So as an honorable Second Appellate Court, section 100 may not allow this court to dislodge findings of fact, my lord, unless the findings of fact are perverse. And are they perverse? I'm confident I have managed to convince this honorable court that in view of the 2010 judgment of the Supreme Court, findings have to be considered as perverse. If the findings of fact are perverse, this honorable Second Appellate Court can interfere with findings of fact also. So the factual conclusion reached by the First Appellate Court was that in view of the regulations of 1880, Transfer of Property Act does not apply to the tribal areas of Meghalaya. That is a perverse finding, my lord. And this Honorable Second Appellate Court, even under Section 100 CPC, is entitled and empowered to disturb and interfere with perverse findings of fact, my lord. So, my lord, I've stretched out my hearing over 2 or 3 days. If Lordship allows me to submit a written synopsis of my submissions, that I'll be obliged, because all the submissions made over 2-3 days will be compiled in one place, my lord. And of course, I'll reserve my right to respond on issues of law based on what they submit, my lord.
You still have to answer that issue as far as the
Yes, my lord. Yes, my
Transfer of Property Act.
yes, my lord. I'll come back, my lord.
Yes, ma'am.
Your Lordship, if I may humbly pray that this matter may be taken in the second half or as per Your Lordship's convenience, because the arguing counsel in this matter is before courtroom number 2, Your Lordship.
Yes, Mr. Jinder.
Lordship, second half may be slightly problematic. Any other date?
Next week.
Next week, Your Lordship.
But Mr. S. Jinder, letter counsel for the appellant, who has concluded his hearing, who has concluded his argument, and has submitted that he may be allowed to file written synopsis of his argument. Next, Miss letter counsel for the respondent has sought for time for the respondent to reply, to reply on the ground that the learned senior counsel who is leading the case is indisposed. Premium, list this matter after 1 week for further hearing.
In item number 1, for correction of the cost title, my lord, if it's reflected in the order so that the registry may permit me, my lord.
It's not so material. You can just do it by hand.
Registry might not allow me, my lord, if there's no order of this court, my lord.
That will have no bearing on the faculty. It is to point out to you that you have to be careful next time.
Yes, my lord.
Unless it will materially affect
No, my lord.
jurisdiction. But you should be careful. No?
Yes, my lord. I'll be careful next time. Instead of clear it, it turned out to be Shillong.
Should cut down to and the copy of the respondent.
Yes, I'll do that. Yes.